Thank you very much, Paul. Paul draws your attention to a number of procedural problems that have been present throughout this entire administrative process. Those procedural problems, other than the ones, more of which occurred today, have been addressed in past articles and letters that my office has sent to the various persons involved in this disciplinary process, predominantly Mr. Zaid. Those are all a matter of record, and I trust that record has been provided to the board and will be adequately reviewed. I would like to begin by addressing the fact that the board has decided to hear deliberation on this matter behind closed doors. I noticed there are lights outside your building, and I thought about, why would you put lights on the outside of a building? Why would somebody do that? Well, presumably so that things can't be in the darkness. They'll be in light instead. Well, why wouldn't you want darkness? I thought about that for a few minutes. Only reason I can think of is that things happen in darkness that people might not like. People might do something a little bit differently if they're in the light versus if they're in darkness. They might be embarrassed of what they're doing in the darkness. Overall, light encourages better behavior, and people might see what you're doing. I think that can very aptly be applied to the deliberations of this board. Section 5495.3 of the Education Code does certainly allow for closed session on matters pertaining to employee discipline. However, it is a presumption of the Education Code that all board meetings are conducted in the open under the scrutiny of the public. The only exceptions permitted to this are exceptions which are explicitly authorized by the Education Code. And what the text of that section says is that if an employee has requested a public session will be granted. It has no caveat that's placed on this. It does not make allowance for a board to close deliberations as part of the session in the open, part of the session behind closed doors. That is not allowed. The Education Code explicitly states that if an employee requests for it to be conducted in public, it will be. The people are the only legitimate foundation of power, and it is from them that the constitutional charter is derived. That's from the Federalist Papers, Federalist number 49. James Madison wrote that. Government is and should be the servant of the people, and it should be fully accountable to them for the actions which it supposedly takes on their behalf. Any member of this board can still bring that motion for an open hearing. I ask you to consider that now. Very well, seeing that no motion has been made, I'll address first the factual contentions that are made in the notice that was delivered against my client. Central contention of these charges brought against Mr. Evans seems to be that he refused to be tested for COVID-19, and yet no evidence of this charge has been produced, no evidence of any kind. In the 25 pages that we were provided, right here, these 25 pages of evidence that were provided against my client in notice of intent to dismiss him, there is not a word of support to the central contention of these allegations. Nevertheless, the board somehow feels justified to state that respondent has blatantly refused to comply with repeated directives to submit to the required testing. Nevertheless, without substantiation of any kind, the district states that respondent verbally notified Hughes Middle School principal Edward Steinhauser and office assistant Janine Ferrari that he would not participate in the required testing. We have asked at every stage of this proceeding for a shred of evidence to substantiate that allegation, and we have not been given anything. We actually had just another meeting last week where we addressed this point directly with Deputy Superintendent Tiffany Brown. We asked her where they were getting this information. I actually just got her response about an hour before this hearing today. She doesn't even address the question. By the way, this was an appeal to David Zaid's letter, that was a letter of reprimand that was made against Mr. Evans, and we received this email from David Zaid's account, despite the fact that the appeal is supposed to be heard by an independent third party who is disinterested from what's going on. I usually don't have disinterested people send my emails for me. As a matter of fact, that appeal is still pending. We were told that that was the final appeal, the letter of reprimand. That is not the case. Letter of reprimand is one of the points of evidence that is attached to the notice against Mr. Evans, and that appeal is still pending. Now, obviously, we can't prove that the conversations that are the only shred of evidence against my client didn't happen, but we can at least be given an opportunity to face Paul's accuser. Frankly, we don't even need that. Even an opportunity to face some kind of statement from his accuser would be better than what we got. Instead, these supposed conversations on which the entire complaint is based were introduced as hearsay by someone who was not even present when they supposedly took place. I would call the evidence fabricated, but even fabricated evidence is still made to look like evidence. Our repeated requests for discovery on these matters have been rejected or ignored. Now, it's certainly true that Mr. Evans has not submitted any testing to the district. Pursuant to 21 U.S. Code, Section 360 BBB3A1, it's explicitly stated that tests that have not received full FDA approval, which are only authorized for emergency use pursuant to the Secretary's powers, may not be compelled as a condition of employment. Therefore, when the board refers to required testing, I can only assume that what they mean is testing that isn't subject to emergency use, testing that has full FDA approval. Despite the fact that it's the district's legal responsibility to provide access and compensation for all requirements that it imposes on employees, my client searched long and hard for tests that the district is requiring, tests with full FDA approval, only to later be told by David Zaid, the person who originally recommended these charges against him in a December 9th letter, that full FDA approval was a set of conditions which he knows do not exist. So what was my client expected to do? Create his own test, spending millions of dollars on the approval process and then presenting the application to the FDA on his own? In the few weeks before the start of the term? You understood full well that the requirement you had imposed on my client was one that was impossible for him to achieve. And yet you expected your employees to comply with unapproved testing instead, which many of them did. You set before Paul a Herculean task, expecting him to fail so that you could wash your hands of him. Again, the notice recommending his dismissal also claims that Paul has been unable to report to work since the beginning of the school year. This, too, is an outright fabrication, and it's not supported in the evidence. Paul has been very, very clear throughout this entire process that he wants to return to work and that he is being kept from doing so against his will. The only thing preventing Paul from going to work is the school board's insistence that Paul take non-existent tests. Now, you've assumed that Paul's a threat to the community because he won't submit to these non-FDA approved tests. But not once has any evidence been produced to show that Paul is a threat to the community. Not once has anyone provided any reason to believe that Paul is carrying COVID-19 or that he risks spreading COVID-19 to others. Instead, almost like a witch hunt, you've put the burden on him to show that he's not a threat, and then insisted that he do so on your terms. Now, this is made all the more apparent by the fact that you now claim the inability to accommodate Paul's sincerely held religious beliefs. You acknowledge their validity, that was acknowledged by the school district, and yet those beliefs, which apply to both vaccination and unapproved testing, are ones that you claim unable to accommodate. I find that very hard to believe. Page 2 of your notice to dismiss Paul lists his duties. You can look at his duties in that list that you guys provided. It should be in the papers that are before you right now. But turning to page 2, we see listed among the other things there that, obviously Paul's primary duty is, of course, to assist deaf and hearing impaired students. If anything, I would say that lip reading is something that ought to be substantially less likely to be a threat than speaking out loud because you're not using your mouth, but I digress. Among other duties, in addition to helping hearing impaired students, is to assemble material for classroom projects, make charts or tapes and prepare displays, set up and arrange supplies and equipment for student use, decorate classrooms, resource rooms, libraries, and other student areas, perform a variety of routine clinical duties such as filing, taking roll, collecting monies, filling out forms and applications, maintaining records, compiling lists and reports, correcting papers, assisting in inventories. The list goes on and on. None of these activities are activities that interface directly with students or faculty. I find it very difficult to believe that out of the, I looked it up, apparently there's over 12,000 employees of the school district. I find it very difficult to believe that out of those 12,000 people, there's nothing that Mr. Evans can do within his capacity to be accommodated. Yet that's nevertheless the claim that the board has taken. If there's some unimaginable reason that he can't, we're yet to hear it. Until then, I have little choice but to presume that you're discriminating against his religious beliefs. You can look at the actual charges that are brought against Mr. Evans. They're on page 1 of that notice that I just referred to. They're things like incompetency and inefficiency, insubordination, inattention, dereliction of duty. Now, if the only factual contention being made here is that he didn't submit to tests, how does that constitute any of those things just described? How is that evidence of discourteous conduct or willful, persistent violations of the provisions of the Education Code? These are not charges. These are excuses for terminating somebody for a reason that you have already determined ahead of time is sufficient cause for termination. In fact, those weren't even the original charges, by the way. Originally, in the letter of reprimand, Paul was accused of bullying. We pointed that out. I guess that was something that was too silly to keep in the actual charges that went against him. So these are the things he's charged with now. Here we have a man who has dedicated his life to assisting students who would otherwise be left behind. And he only wants to be sure that his health is taken seriously by his employer. He's not asking for the world here. He's asking that the tests that he be subjected to, tests that he be subjected to, have themselves been submitted for proper testing approval. Mr. Evans is not trying to avoid work. He's ready to agree to a perfectly reasonable accommodation that would allow him to go back to his job, offering support to students who are hard of hearing and need the support of this school district. The fact that the school board is apparently ready to deny valuable resources to disadvantaged students over something as absurd as requiring Mr. Evans to agree to tests that have not been proven reliable is unconscionable. You don't have to go down this road. It's not too late to stop. I know that you think this is out of your hands. I know that you think you're doing what you've been ordered to do by people from the state or from the county. That's not true. I've given you ample legal authority in all the letters that I've sent to date. Review it if you're not familiar with it. If you, for whatever reason, were not provided copies of that, my office can provide those copies. Let us know. There's pages of it. I won't belabor that at length today, but just know that the law is on your side if you choose to keep Mr. Evans here. The responsibility is yours. Please do your duty.